Evening, everybody. It's so good to see you all. I know I can't really see you all, but we all have good imagination. So I imagine you out there, and maybe next year, by some chance, we will be able to do this in person and we'll get to see you all. For those of you that don't know me, I'm Judge Harvey Silberman. I sit in Pasadena. I've been on the family law bench for 19 years, 8 of them downtown, and 11 of them out here in Pasadena, where I have beautiful snow-covered mountains today to greet all of us. Before I introduce my esteemed colleagues, I want to thank everybody from the Beverly Hills Bar, Erin and Gina and Kathleen and Chelsea, and everybody that really helped us put this together. They're wonderful and interested and accommodating, and we thank them. We are so lucky today. Four Corners is named such because while I sit out here in the San Gabriel Valley, we have Commissioner Aharonov from the San Fernando Valley. Commissioner was a family law attorney for many years before he took the bench, and we're so glad to have him. And then from downtown, we have Judge Pellman, who is our reigning expert on dependency family law crossovers. And I know she's my personal Witkin on that topic. So I certainly am glad that she's here. And then from way down south, we have Judge Weiner with us today, who we all have to thank for the wonderful slideshow that you're going to see. And we're so glad he's with us to represent the fourth corner of Los Angeles County. Now, this year, unlike years past, there really were not a huge amount of cases to cover this year. So we've built in a little extra time should anybody have any questions. We only ask that you put the questions into the Q&A function, and somebody from the bar will sort of gather them up for us and present them to us at the end if we have any time. Okay? So if there's, let me think if I've forgotten anything. I don't think so. So if we can have the first slide, I'm going to ask Judge Weiner to begin, and off we go.
All right. Okay, if I could have the next slide, please. That's just our introduction. Okay, so first of all, good evening, everybody. I want to thank the Beverly Hills Bar Association for hosting this event and for asking me to participate. It is a real pleasure to do this with my friends and colleagues, and we will dig right in. I'm going to ask you to temper your expectations for the first case because it's a pretty straightforward case in marriage of Thompson, and it really has to do with first in time issues. So what happened in this case was the husband filed a petition for separation in California and mailed a summons to the wife who was living at the time in Massachusetts. The wife got the summons, signed for receipt of it, and then she petitioned for dissolution in Massachusetts. Husband was personally served in California on May 16th, and on the very next day, he tried to amend his petition to also seek dissolution, and then he mailed the new summons to the wife. And the Court of Appeal held that the state of Massachusetts had acquired jurisdiction over both parties in the dissolution matter before California did, because the trial court didn't have personal jurisdiction over wife at the time the husband had filed his original separation petition. The husband did make a relation back argument in that case, and the Court of Appeal did address it and noted that even assuming that the petition related back to his original separation petition, the timing of the separation action on wife didn't really have an impact on their analysis because California didn't have personal jurisdiction over wife when husband later amended the first petition. So it really was a first in time issue, and the court said that it only applies when both in rem and in personam jurisdiction applies. So again, a pretty straightforward case, but one that was still important because we oftentimes see these cases where there are parties in multiple states. Next slide, please.
Okay, in re marriage of Aviles and Vulovich. And my apologies to the Aviles and Vulovich families if I'm not pronouncing those names correctly. The facts in this case fall under the "you can't make it up" heading. It is an opinion that when I first read, I strongly questioned parts of it. Because it really changes the law in a profound way. We hear all sorts of stories, and it's not uncommon for people to turn up years later and find out, well, you may be married, but you're not married to the person you think you're married to. You know, the person you've been living with for the last 20 years. Because you see, the divorce that you relied upon is not really lawful. And I think all of us, lawyers and judges who are listening, all of us have sort of been in court when we've heard this fact pattern. This case also stands for the old adage, the third time is the charm, as these folks had 3 different wedding ceremonies and still couldn't come up with a legal marriage. So let's go back to the beginning, because the facts are a little convoluted, as they mostly are in putative spouse cases. In 2006, Jessica files for divorce from Mr. Vulovich, with whom she has 1 or more children. Now, she believes that 6 months after she files, she becomes automatically divorced from Mr. Vulovich. And so a year later, thinking that she's divorced, in 2007, she starts dating Pedro. And they, it appears, like each other. And so in March of 2011, Jessica and Pedro run off to Las Vegas and get married. That's March of 2011. Now in May of 2011, Jessica finds herself in child support court with Mr. Vulovich. But Pedro didn't go with her because he and Mr. Vulovich don't get along very well. So there she is in child support court, and the judge breaks the news to her that she's not divorced from Mr. Vulovich because there, of course, never was a judgment. So in the following year, in March of 2012, she finalizes, finally, her divorce from Mr. Vulovich. But apparently, she doesn't share any of this news with Pedro. I guess it just slipped her mind. And in April of 2013, Pedro decides, even though they've gotten married in Las Vegas, that he wants a church wedding. And so Jessica goes through months of classes and trainings and converts to Catholicism, and she and Pedro are married in a Catholic church. However, they neglect to get a license for this marriage. And then in September of 2013, as if the first 2 wedding ceremonies weren't enough, Pedro and Jessica and 200 of their nearest and dearest gather at a winery, and Pedro and Jessica are married for the 3rd time, once again forgetting to get a license. So 3 marriage ceremonies and counting. So alas, despite all of those ceremonies and gifts and religious conversions, ultimately, it doesn't work out for Pedro and Jessica. And Pedro files for divorce in January of 2020. Now, whilst going through the various documents that usually us judges ask them to look through for their divorce, Pedro discovers that Jessica was still married when he married her in Las Vegas, thereby invalidating that marriage. In 2020, Jessica wants spousal support and attorney fees from Pedro. In fact, she wants lots of spousal support and attorney fees from Pedro, who doesn't want to give her anything. So Pedro argues that they're not lawfully married And she's not a putative spouse because she knew she was married to this other guy at the time she married Pedro, or shortly after, when she finalized her divorce from Mr. Vulovich. So the trial court rules that Jessica was a putative spouse, a ruling that both the appeals court and frankly, I agree with. I think she was a putative spouse. She may have had a good faith belief that her filing her divorce papers automatically divorced her in 6 months. And so the trial court, based upon that finding, they ordered Pedro to pay $9,353 per month in spousal support and $12,541 in attorney fees. The question in the case really turned on what period of time was Jessica a putative spouse. Perhaps from March of 2011, when she got married in Vegas, until May of 2011, when she found out the marriage was not legal. Maybe during that period of time, she was a putative spouse. And frankly, that's what the law had been for decades. She was a putative spouse from the date of the unlawful marriage until she knows that she wasn't legally married or should have known that she was not legally married. So in May of 2011, the child support judge told her that she was still married to Mr. Vulovich. So that should have done the trick. And so she really, based on what the law had been, was a putative spouse for 3 months. And frankly, the case law on that goes back to the 1940s, saying that she should only be entitled to support and her attorney fees for the period of time that she was a putative spouse. In other words, from the marriage till the date she found out or should have found out that it wasn't a legal marriage. But the Court of Appeals here says, oh no, it does not require that the spouse believe the marriage is valid in the present, only that they had a good faith belief that the marriage was valid at the time. And that case from the 1940s, well, listen to how they distinguish that. The case in the 1940s, the wife only made claims for recovery of services rendered. She didn't ask for spousal support or property division in that case. So once you're a putative spouse, you're always a putative spouse. This is a ruling that can really have major implications on these kind of cases. And there are opinions that, frankly, it invites dishonesty. But that's the ruling. And the Court of Appeals basically treated a putative marriage as a regular marriage, basically saying, look, once you're married, you're married. And when we find for putative spouse, once they're a putative spouse, they're always a putative spouse. And one more thing. Pedro claimed that Jessica was a bigamist. And so she couldn't claim being a putative spouse because she was a felon, after all. And his lawyer argued that famous arguments. Your Honor, there is not one case in all of California legal history that says otherwise. So lawyers, be careful if you make that argument, because the Court of Appeals said, actually, there is a case, and the Court of Appeals cited the case. So aside from losing the case for Pedro, which was bad enough, the lawyer dined on crow that evening. All right, next slide.
All right. So from involuntary or not meaning to be bigamists to willful bigamists, my case is all about willful bigamy. I would say in reading this case, there's a lot of mental gymnastics that I think you have to engage in, the trial courts had to engage in, and then ultimately the appellate court needed to engage in to kind of make sense of all of it. Because when you actually put the facts in order, you wonder why what happened in the trial court happened that way. So I'll give you a little bit of a taste. So in 1987, husband married wife number one. Then in 2012, he married another wife. She knew that she was the second wife. They married under Lebanese law, which was allowed. In 2013, husband files a divorce from wife number one. In 2014, husband unilaterally terminates the marriage to wife number two, which was allowed under Muslim law. And then later in 2014, 2 months later, wife files a petition. It's actually interesting because we've learned, if you read the family code, you find out petitions that are often not used but do exist. In this case, a petition for spousal support without dissolution of marriage. Apparently, you can create such a pleading and a complaint under Family Code Section 4303, and that's what wife did. The husband objected. He claimed that the marriage was invalid. And in July of 2015, interestingly, the court found the Lebanese marriage to be valid. But they found that the termination that husband engaged in Lebanon violated due process and was an invalid invalidation. Then husband decides to file for annulment from wife number two. And later, for whatever reason, again, head scratcher, he and wife number two enter into a stipulation for spousal support, and they decide to bifurcate the issue of nullity. Husband, 2 months later, decides to amend the petition to divorce before the court made a decision on nullity. And by all accounts, when the parties went to trial on their divorce, they wanted the court to completely bypass the issue of an annulment and enter a judgment of divorce. I don't really understand, and there's no explanation as to why husband flip-flopped from an annulment to divorce. I wish there was more explanation to understand what happened next, but interestingly, the court then had switched. The trial court had transferred the case to another judge in the courthouse and asked that they handle the rest of the case, and that judge was left with the previous judge's decision that the Lebanese marriage was valid, but now decided to bifurcate the issue of an annulment. So now somehow the trial court came to the conclusion that while the Lebanese marriage was valid under Lebanese law, it was invalid and void under the family code. So the appellate court was left with that, frankly, bifurcating the issue of validity and somehow coming to two disparate decisions within the trial court, and then had it appealed. The annulment was appealed. And what had happened, interestingly, is neither party wanted the annulment. The court said we're proceeding on the nullity. And wife said at that point, well, if you're going to proceed on the nullity, I also want you to consider whether I'm a putative spouse, even though I knew I was a bigamist. So no one was surprised when the trial court came to the decision that the marriage was now void and that wife was not a putative spouse. So what is really nonsensical in the decision is the Court of Appeals trying to explain how the trial court could properly find that a Lebanese marriage could be validated, but then void. And they kind of essentially said, in a sense, a valid marriage doesn't mean it's not a void marriage. That's really the explanation. And I think that it was an attempt to harmonize two lower courts' orders. But if anything, from a practitioner standpoint, it should be a red flag, any attempt to bifurcate an issue of validity versus whether a marriage is void or voidable. You could end up with very disparate decisions, especially since the trial court was correct. It looked under Lebanese law and said it is a valid marriage under Lebanese law. And because the California Family Code says we look at the validity of the marriage based on the jurisdiction in which the parties married, you come to that conclusion that it is a valid marriage under Lebanese law. But the bigamy statute says, and the Court of Appeals clarifies, that we have such a negative public policy against bigamy, that really overrides even a valid marriage. And so that was the way the Court of Appeals tried to distinguish the two decisions beneath it and find and affirm it all. So it's a very interesting kind of perplexing decision in that how the mechanics and the procedure happened, but ultimately the decision, I think, is the sensible decision, which is clearly there was bigamy. Clearly, there was no way around the bigamy. It was invalidated, and the putative spouse decision couldn't stand as finding wife as a putative spouse when she knew all along that she was a second wife. So all in all, you do the gymnastics, but you stick the landing. So I think that's a good decision. Next slide, please.
Okay, so now we're moving on to a probate case, which has an interesting crossover with parentage. And I have to admit that I guess I'm a visual person. So when I was reading this case, I had to make a family tree chart because it gets quite complicated, but I'll do my best to simplify it as best I can. So in this case, we have a decedent who dies without a will, dies intestate. Appellant is a first cousin of decedents on his father's side. And basically the crux of this case is that appellant Shannon doesn't want to share the money with Judy, who is the cousin on the mother's side. But that's where this case gets kind of interesting. The question in this case is whether or not Judy is in fact an heir under the law. You see, what happened was Judy's father, David, was decedent's uncle. Judy was neither the biological or adopted child of David. However, when Judy was 2 years old, she was dropped off at David's home, David and Frances's home, by her father, who had been taking care of her after her mother had abandoned her. So as we say in New York, you know, the father went out for bagels and lox and never came back. So Judy's dropped off at David and Frances's house, and they're living in Kentucky. At some point, they move to Indiana when Judy's about 11, and this is where the evidence is. So the evidence shows that when they're living in Indiana, David and Frances hold out Judy as their natural, albeit not biological, child. She's registered under their last name. As she grows up, she lists Judy and Frances as her parents on her marriage certificate. And by the way, she unfortunately has died, and this is actually her heir who is arguing this case. And on her death certificate, it's also listed that that Frances and David were her parents. So under Indiana law, if this were to be heard under Indiana law, David would not be considered the parent of Judy under their intestate succession laws. And Shannon argues, well, it's really not fair that we use California law when under Indiana law, Judy wouldn't get anything. The trial court disagreed and the Court of Appeal affirmed. And the court said, California applies when there's a parentage issue and a person who claims to be an heir of an intestate decedent who died in California and who lived in California, even if that parent and child relationship was effectuated outside of California. As an aside, I thought this was an interesting little fun fact that it's noted in the decision, I don't know how the evidence came in, frankly, that David, I guess, purposely did not go to court to legally adopt Judy. He himself had been adopted and had been in foster care. And essentially, he wanted nothing to do with government social services. So apparently that's why he never legally adopted her, but he treated her in all other respects as his own lawful child. So once that choice of state issue was resolved, the question then becomes, does David qualify under the Uniform Parentage Act as a presumed parent, Family Code 7611D? And that's not a really hard issue for us in that, of course, David did qualify because he held Judy out as his own child and brought her into his home. Shannon made an interesting argument. So she said under 7612, which of course says that the presumption can be rebutted by clear and convincing evidence in an appropriate case. And she said, well, I mean, this is an appropriate case, not because she really had any facts to dispute it, but based on public policy. And what she said was that it would be against public policy to reward a person who has an unsanctioned relationship, or to put another way, an irregular parent-child relationship in one state and give them inheritance rights in the other. That didn't go very well. So she made another argument that said, in essence, that California's child protection laws would be thwarted by sanctioning this relationship, and it also might encourage rather than discourage parents from giving their children away. Maybe not the strongest arguments, but at any rate, the Court of Appeal was unpersuaded, and plus 7612 says nothing about being rebutted on public policy grounds. And the Court of Appeal again reiterated our long-standing social policy of preserving the ongoing parent-child relationship, and reminded us that these presumptions are driven by the state interest in preserving the integrity of the family and the legitimate concerns for the welfare of children. Again, reminding us that the state has an interest in preserving and protecting the developed child-parent relationship, and even if that there is no biological connection. So Judy was declared the legal heir, and Shannon had to share. So interesting case. Next slide.
And Judge Pellman, you found the fact pattern there? Complex?
No, just the family tree.
You can't make it up. Okay, so the next case, salmon. I had all sorts of aquatic jokes ready to start this case off with, but my own family groaned at them last night, so I will spare you all of the aquatic references, except to say, of course, that the salmon case came out of Riverside County, and we'll leave it at that. This case actually happily settles a split in decisions between the first appellate district and the second appellate district on the issue of mutual restraining orders and the application of Family Code Section 6305, which designates the process and procedures when a court considers issuing mutual restraining orders. So let's go back and look at some of the ledge history on this matter, so we sort of understand it a little bit better. We all know that much of domestic violence occurs behind closed doors, and getting at the facts is not always easy. And there was concern that a perpetrator could simply claim that there was mutual violence, and that could coerce survivors from seeking protection and or skew custodial and protective orders that come out of domestic violence hearings. They were concerned that a court might, as a matter of expedience, that a trial judge, just to make things expedient, simply issue mutual orders rather than attempt to get at the difficult to discern true facts of the case. Basically, that a court would just throw up their hands and say, listen, I don't know what happened here, and so I'm just going to issue restraining orders against both of you. And the legislature clearly wanted the courts to engage in, and I'll quote out of the leg history, careful evaluation of a thorough record, unquote, in all cases in which parties have competing petitions seeking DVPA restraining orders. And so what was created was Section 6305 of the Family Code. And 6305 mandates that the court, us judges, shall not issue a mutual order enjoining the parties from specific acts of abuse unless it makes detailed findings of fact indicating that both parties acted as a primary aggressor and that neither party acted primarily in self-defense. How easy do you all think that is? Mm-hmm. Firstly, I think that primary aggressor is a terrible misnomer, and it often confuses the issue. Primary can sometimes mislead one to think that the initial aggression is what we're looking for. I try always to use the term which actually comes out of the Penal Code, Section 836, which uses the term dominant aggressor and defines that as the person determined to be the most significant rather than the first aggressor, and specifies various factors to consider in making such a determination, including the intent of the law to protect domestic violence victims from continued abuse, the threats that create a fear of physical injury, a history of previous domestic violence between the persons involved, and whether either party you could believe acted in self-defense. So I try very hard in my cases to always look for the dominant aggressor rather than primary, so we're not confused about that.
Wouldn't you say, Harvey, that this issue has come up in cases for quite a while? There's a lot of confusion about dominant aggressor and when 6305 comes into play, especially when the question of when the restraining orders come out of either the same incident or different incidents.
Yeah, it comes up all the time. And which is why, at least for me, I turn to the Penal Code to get, and they not only supply a definition, they give sort of criteria to look at. So I use that Penal Code 836 all the time in my findings when I have to do this. In this case, the husband was hitting one of the kids with a belt. We've all seen that. And the wife intervened, and the husband battered her, and he was arrested. And she filed for a domestic violence restraining order. Now, a few weeks later, the husband filed for his own restraining order, claiming he was only acting in self-defense after the wife intervened, and citing multiple past instances where he claimed the wife committed domestic violence against him. So the trial court found that the husband was the primary aggressor in the incident involving the child and issued a restraining order against him. And although the wife was deemed the primary aggressor for past incidences, it did not issue a mutual restraining order against her. Now, the husband alleged that the trial court erred in making all of the primary aggressor findings because it argued, well, these were two petitions. They needed to be determined on their own merits, independent of the other, regardless of whether they were heard together or not. So, in other words, these requests should not have been heard as requests for mutual restraining orders. Each should have been heard separately. There were different incidences involved. They were filed a couple of weeks apart from each other. And 6305 should not have even applied because they were separate incidences. And for many years, the husband seemed to have a point. So starting back in 2004, when I took the bench, we were guided on this application of 6305 by the first appellate district decision in a case called Connes, C-O-N-N-E-S-S v. Satram, S-A-T-R-A-M, 122 Calat 4th at 197, which concluded that two entered close in time to each other, but following separate hearings on different days did not fall under the definition of mutual orders for purposes of 6305, despite the fact that the orders resulted in a restraining order for each party to dispute. And that was sort of the rule. And I made many rulings under this guideline over the years, and I'm sure many of my colleagues did. If they seemed like separate incidences and they were filed a week or two apart, you treated them as separate matters. In 2018, in the Melissa G. v. Raymond M. case, 27 Calat 5th at 360, the second appellate district took a completely different approach. They found that a mutual order may refer to a single order restraining two opposing parties or two separate orders which together accomplish the same result as a single order. And the Salmon Court found that the Melissa G approach is the correct approach. They applied the principle of really a form over substance. And they said that two separate orders that collectively end up accomplishing the exact same result as a single mutual restraining order are the functional equivalents of a mutual restraining order. In other words, come on, they may be filed 2 weeks apart. They may be even filed in different districts. But if they accomplish the same thing, which both parties are to be somehow restricted by restraining orders, they're in fact mutual restraining orders. The court also wanted to make sure that the legislative intent was not circumvented by clever, manipulative filing dates and other machinations. They want to make sure that if the outcome of these kinds of hearings is mutual restraint, then the orders have to be the product of careful evaluation of a thorough record and not simply the result of the moving party yielding to the other party's importunities of the court deciding about a mutual order as an expedient response to joint claims of abuse. In other words, oh, it's really hard. I don't know what it is. I'm just going to restrict them all. So special findings pursuant to 6305 will be required if the effect of the hearing is in sum and substance a mutual restraining order, even if the incidents are separate and distinct and filed at different times and even heard in different locations. So look to the result. If the result is that this could end up in mutual restraining orders, 6305 will apply. All right, next slide.
Okay, this is another domestic violence case. This is a short case, but an important one because it discusses a little known aspect of an issue that we deal with a lot, which is when do we include children in restraining orders? And I would recommend that you read this along with the JH versus GH case, which is discussed in the MS case, because they really are some of the only cases, I think, that discuss this issue in great detail, and it's something that we all have to deal with on a regular basis. And it does drive home that the standard for including children in a restraining order is somewhat imprecise, in that the standard under 6320 is there good cause? So this was a long-term marriage with 3 children. And soon after the separation, mother filed a DVRO for herself and her 3 children. She was granted the temporary restraining order based on evidence that father threatened to kill mother's boyfriend, that he had harassed her, that he had stalked her, and that he had also engaged the children to spy on mother. At the hearing for a permanent restraining order, the court found multiple instances of stalking and harassing against mom. And as to the children, the court heard testimony from the oldest child as well as the maternal grandmother. Mother had also testified that the father would engage in physical play that was exceptionally rough, such as choking them, slapping them upside of the head. And on one occasion, they used the term choked out a child in public, I think during a trip to Disneyland. The eldest child testified that at his father's behest, he helped his father to find out where mother's boyfriend lived, and that his father had told him that he had gone to the house, spied on this gentleman, and looked through the scope of a mounted rifle, and that he was planning on harming mother's boyfriend. He also testified that the father frequently insulted, belittled, and screamed at him and his siblings, and that he feared for his safety. The grandmother, maternal grandmother, testified that she saw the children freeze with fear, was the term, when father engaged in what he called to be just playing around, and that the children would often fight back tears when their father played with them or slapped them or yelled at them. So the court did grant the restraining order and included the children as protected parties. The father appealed, and specifically appealed, the inclusion of the children under 6320. So the question then becomes, what is good cause? And what the court first said is good cause. In order to determine good cause, you have to look at the totality of the circumstances. And when custody orders are sought, whether the failure to make such orders would actually jeopardize the safety of the children. So looking back at the most recent case, JH versus GH, we know that that case clarified the question of whether a showing of potential jeopardy to the safety of the children was a predicate, had to be a predicate to the inclusion as protected parties. And the court had said no. Certainly a finding that the children's safety could be at risk might be sufficient, but it's only one factor in the totality of the circumstance. So then father tried to argue that the current case was similar in facts to the JH case, where the court in fact did not include the children. However, those facts were clearly distinguishable. In JH, first of all, significant time had lapsed since the parties had separated. The father had engaged in parenting therapy, a batter's intervention program. He was remorseful of his past acts of DV, and he had changed his alcohol consumption. And quite importantly, the children wanted to continue to see the father, and they were working on their reunification. Whereas in this case, there was certainly no evidence of remorse. Father had not engaged in reunification therapy, even though he was invited to do so, and had clearly not engaged in any other ameliorative actions that would have shown his remorse or his intention not to repeat the actions that led to this restraining order being issued. So based on the totality of those facts, the children were included, and this is a very nice case which you can use to thoroughly discuss when you can include children in a restraining order and when you can't. Next slide.
Okay, so this case is the Abelkader versus Abraham case. And it's interesting from a procedural standpoint as well as sort of a legal standpoint. So in this case, the mother filed a request for a restraining order against father, which was issued against father. But then, as sometimes we'll see, the protected party came in and asked to terminate that first restraining order. But then, lo and behold, some time passes and I forget exactly how much it was. I think it was about 6 or 7 months later, the mother asked for a new second restraining order. So she essentially renewed her request for that restraining order. And the court had a bench trial on that, on not only the request for the restraining order, but also on the issue of custody and visitation. The court made a specific finding in that case that the father had committed an act of domestic violence back at the outset in 2018, but the court then went ahead and denied the mother's request for a restraining order because she had asked for that first restraining order to be terminated. And she stated at that time that she was no longer in need of protection. And then the court proceeded to make custody and visitation orders and granted the parties joint physical custody of the children. And the takeaway from this case, really, it may seem self-evident, but I think it's really important because sometimes you'll see orders that might not strictly follow this. The Family Code Section 3044 presumption, which of course we are all familiar with, that presumption says that where a person is found by a court to have committed an act or acts of domestic violence against either the other party seeking custody of the children or against the children, there is this presumption, of course, that it is not in the best interests of the children to grant the party who has committed the abuse sole or joint legal or physical custody. And here the Court of Appeal made it very clear, and it cited, I think there was a string cite of cases that, that presumption is mandatory. And courts have no discretion whether or not to apply 3044. And here, of course, the court made a finding that that the father had committed an act of domestic violence. And the fact that it chose, for whatever reason, to award the parties joint physical custody did not somehow excuse the trial court from applying that presumption. The Court of Appeal goes on to point out that under subdivision G of section 3044, that if there's an allegation in an evidentiary hearing or a trial in which custody orders are sought, that if it's an allegation of domestic violence, the court must, uses the term shall, mandatory language, make a determination as to whether section 3044 applies prior to issuing that custody order. And the only exception to that is the court can continue the matter but only if it's necessary to determine whether Section 3044 applies. So it is a mandatory application of Section 3044. And in this case, it was really undisputed that the trial court found that the father had committed an act of domestic violence, but there was nothing in the record, and the court is required to state its reasons, addressing each factor in Section 3044 subdivision B as to the rebuttal of the 3044 presumption. And because there was nothing in the record in this case that indicated that the court had gone through that analysis to decide that father had rebutted 3044, there was no discussion of the 3044B rebuttal factors or really any other information that reversal was required, and that the court, because it didn't provide that statement of reasons, that it was not a harmless error. So, next slide, please.
All right, and in this case, there's a lot of crossover in terms of the court's analysis of a 3044 presumption. And in this specific case, whether there was a valid restraining order or domestic violence is not at issue. The question is, now that the court has made the decision that abuse occurred, what kind of custody order can it make? And in this particular case, the judge did find that the 3044 presumption applied, but left intact a long-standing schedule that the parties had they had a 3-day on, 4-day off, 3 days with the perpetrator, 4 days with the victim, 3 days with the perpetrator, 4 days with the victim. And the court analyzed a couple of issues. First, under the 3044 presumption, as Judge Weiner just indicated, a statement of reasons is necessary. But in this particular case, mother asked for a statement of decision and the court denied it. I think that the court is very, especially in line now that we do not have court reporters, these issues of what is subject to a statement of decision and what isn't, I think will become much more contentious in our courtrooms. But I think the Court of Appeals was very particular in saying that in these particular circumstances, a statement of decision may have been necessary, and reverse the court on not providing a statement of decision. I think, though, it really is hanging on to the requirement under 3044 for a statement of reasons. And because this trial court specifically didn't give a statement of reasons as to why the 3044 presumption was overcome, I think it bolstered the argument for why a statement of decision should have been necessary in this case. So I think it would be difficult to make the stretch saying that in every case where a 3044 presumption is applicable, the party is entitled to a statement of decision. I think in this case, and in every 3044 case, you're entitled to a statement of reasons. It may or may not be by statement of decision. But in this case, mom specifically asked for it and was denied. I think the other part of this case that's interesting is we have this continuing thought process in the appellate court of trying to define what sole physical versus joint physical is. And sometimes that gray area is difficult to discern. But this case is emphatic, and this is not a gray area. 3 days with one parent, 4 days with the other, by all definitions amounts to joint physical. But this case does give you the definitions that it believes are appropriate to assess what would discern between sole physical and joint physical. I wish that the case was a little bit more specific in telling us what that line is. It's still a little muddled, but it seems that the issue is the significance of the time and the frequency of the time, and really the characterization of the time. Is it a parent who has the sole supervision of the children and the other parent is entitled to visitation? That's sole. Or are the parties really sharing in the parenting in a significant way? That would be construed as joint. I think that the other lesson to take from this case is, from a practitioner standpoint, is when you know that your bench officer may have decided to perhaps issue an order either for your client or against your client after a 3044 presumption has been applied, that looks like it's in that gray area of joint or sole. You have to play that game of, do I want the statement of reasons? Do I want to understand specifically on the record or in a statement of decision, or later on the joint statement you might have to generate for an appeal? What do you want in the record to be omitted with danger to your client if you are the client who may have gotten the 3044 presumption and is not happy with the physical custody order? The omission under this line of cases and cases that we've seen in other years, that omission of the statement of reasons to overcome the presumption may be, and it appears to continue being, an automatic reversal. Not explaining how you get to joint physical, it looks like an automatic reversal and a remand, as there was in this case. So I think a practitioner needs to decide, should I ask? And I think the answer is you should ask, because do you want a valid order that you know will overcome a very obvious appeal if you're the party who is representing the perpetrator and somehow they came with significant physical custody or even joint legal custody? Do you want something in the record for the court to explain itself, with the danger that by asking the court, they might flip-flop and say, actually, now that I have to apply the rule, I don't know if I come out at the same result? I understand that's a dangerous game, but the flip side is you have a very flimsy order. And do you want that? And I think this case is saying to judicial officers, make sure you make those statement of reasons. And I think it tells the parties, saying you should be asking and you should be getting those statements of reasons. So I think for that, while it's a very fairly simple case, to tease out those interesting points makes this case a little bit more meaningful.
I felt that something that is an interesting issue that hasn't come up that I'm aware of, at least recently in any cases, and in this case, the restraining order was granted against or included initially mothers to older children, but not the child at issue, which is interesting, I find. And second, I also felt that the Court of Appeal was plainly just aggravated with the trial court and just felt like the trial court was just, you were doing this before, you can do it again in terms of your custody. And just really didn't want to deal with applying 3044 and just wanted sort of the case to move along.
I think your point is, I think definitely you can read that into this decision. I think it's interesting that the remand order on this said, this is not joint, this is not sole physical. You didn't do it. I'm remanding it back to you. Either make a sole physical visitation order, or if you want to do the 3044 all over again, we've now told you how to do it. Right. And I think that really does talk about the frustration. And we see these cases, last year when we did this, we had similar cases. It seems to be a constant every year, one or two of these 3044 cases where the Court of Appeals is just like, please just do 3044, just do it.
I think it also speaks, looking back at the Salmon case that I did, is the Court of Appeals is saying, with all of these domestic violence cases, we want to see that you thought this out and how you thought about it.
Yes.
I want to see that when you make the determination of a dominant aggressor, when you make custodial orders, when you decide who to include in them, They don't want rubber stamping on these cases. They want to see how you thought about it. And
My
if
notes,
you say how you thought about it, they'll uphold you. If you don't, they're going to send it back.
yeah, my notes on this case say the Court of Appeal is saying, show your work.
Right?
I think also, I think this is a case where we've seen other cases where the trial court has said, and I'm finding that the presumption was overcome, and that's it. And the Court of Appeals says, well, let me see if I can imply what you've decided. This is a case where there was nothing. It says 3044 applies, and this is the physical custody order, and I'm calling it sole. So I agree with Judge Pellman. It's a little bit egregious in that omission, because in cases in the past, just by saying I've at least engaged the discussion of whether it's overcome has gotten the trial court a little leeway. This left no leeway. There was no way around it. And the Court of Appeals, I wonder, I wish there were more facts. I wonder if the trial court could have fashioned the same order and could have found a presumption being overcome. Even just, something to the effect of, to Judge Pellman's point, there must have been a reason not to include that child. There must have been a reason to keep this visitation order intact. Explain yourself. Refer to the 3044 factors. Something. I think that this trial court would have gotten a little bit more leeway. But I agree with Judge Pellman. It's aggravation is what I read in this too. All right, next slide.
All right, well, I was a little bit surprised that this case got published, since for the most part, I feel it reiterates concepts that I didn't think were very much really at issue. But I think a very important takeaway that the justices stressed is something that we often forget, and which I think really bears repeating for both lawyers and judges. We all know that when we're litigating custody and visitation, the best interest of the child is the guiding paradigm. What we forget is that when we're litigating child support numbers and we're battling about how much one parent earns and what they have to pay and how much the other parent needs, ultimately, we're still deciding what order is in the best interests of the children. The guideline child support numbers were passed under a best interest of the child standard. Key, not the best interest of the parents, and not what is ultimately even fair to parents, but what's in the best interest of the kids. And we often see that somehow it's segregated. We do custody and visitation in the best interests of children, and then we do child support. It's the same standard. The order that you come up with in a child support order has to be in the best interests of the children. The guideline numbers have been deemed in the best interests of the children. So I think it's something that's often forgotten and needs to be included. In this case, the facts are something most of us see at very least on a semi-regular basis. In 2017, Dad was earning $15,000 a month and had a 20% timeshare and was paying $1,525 per month in child support. In addition to the support, Mom, who did not work, received gift income from her father, her generous father, of $5,000 a month. Now, 3 years later, Dad had increased his 20% timeshare to a 42% timeshare, and his income had grown to $17,500 a month. Mom was still not working, but her father had increased her gift income to $7,500 per month. So Dad wanted a new guideline order and wanted an order for Mom to go to work. How many times have we heard that? When is she going to go to work? Mom said she could not get by on the $100,000 she was currently getting from Dad and her father. And she resisted any recalculation because she just couldn't survive on the $100,000. She also resisted the idea of going to work because she claimed that all she could get was a minimum wage job. And somehow that was not something she was interested in. and that even though the child was in preschool, her employment would be detrimental to the child's attachment, bond, and personal care. So the trial court basically didn't buy that. And they cut her support approximately in half, and they issued a seek work order based upon her skills and experience. Lady, go out and find a job. And the trial court, interestingly, included that it was making this order in the best interests of the child, found that her going to work would be in the child's best interest. Now, the appeals court opinion starts by stating that the legislature has declared that both parents of a minor child have an equal responsibility to support their child in the manner suitable to the child's circumstances. And it goes on to quote Marriage of Hine by reiterating that a parent's first and principal obligation is to support the parent's minor children according to the parent's circumstances and station in life. Both parents are mutually responsible for the support of their children. The guideline seeks to place the interests of children as the state's top priority. The state's top priority is supporting your children, not paying your own rent, not making your car payments, not going on vacation, but supporting your kids. Now, the family court code itself allows a court to consider the earning capacity of a parent and to impute income to an unemployed or underemployed parent, which is a method we use frequently. Additionally, although I don't do this as often as when I impute income, is that the court may require an unemployed parent who is in default of a child support order to submit evidence that the parent is seeking employment, and it may require either parent in a proceeding involving child or family support to attend job training, job placement, vocational rehabilitation, and work programs, and provide documentation of participation in the programs in order to enable the court to make a finding that good faith attempts at job training and placement have been undertaken by the parent. I don't know about my colleagues. I don't do that often. I often will say, bring me a list of all the jobs you're applying for. But I don't know if I have made too many orders as comprehensive as this court did. Clearly was not amused by mother saying that she couldn't get by on $100,000 and she couldn't lower herself to go get a minimum wage job. The lady, not only could she not do that, she had a college degree, she had some job experience, and the court found that that was enough to order her to go get a job, even a minimum wage job. And the Court of Appeals found that that was enough evidence. That was substantial evidence, enough to support the trial court saying, madam, go get a job. Additionally, she claimed that her father's gifts could stop at any time, so they should not be calculated as part of her income. But most of us are familiar with marriage of alter, and we know that there does not have to be a guarantee that gifts will continue indefinitely for a court to consider the gifts as income. So that was right out of marriage of alter, and the appeals court said, forget it. Finally, as to her claim that her getting a job would negatively impact her child, the court made clear that the burden of proof for that concept was on her, was not on the father to show that it wouldn't impact the child. And since she put on no evidence that would support the claim that her getting a job would hurt the child, the trial court was correct in not considering this argument. So aside from this clarification as to the burden of proof as to the negative impact on the child, I think the takeaway is to remember that what the trial court was smart enough to state on the record, that it found that mother getting a job and adding that income to the household was in the best interests of the child. Next slide.
All right, for some reason, I got another probate crossover case. this is not an uncommon situation where one spouse dies prior to judgment. The difference is that this one got a whole lot more complicated than what usually happens, at least for the family court judges, which is, I'm really sorry the spouse died, but now the case is not mine and the probate court has to deal with it. So this one has some very interesting twists and turns. So the parties, after 36 years of marriage, separate, and in September of 2015, they go to a mediator and they sign a marital settlement agreement. The marital settlement agreement is a 5-page handwritten document. It divides all their property. It specifically addresses their financial issues, including 401ks, timeshares, cars, personal property, household items, and the family residence. And it even goes so far as to say that the parties have read and considered the agreement, that they understand it, and that they request that the court adopt this stip in agreement as the court's order and waive further notice. And we all know what that usually means. So both parties file their TDDs, and father or husband files a proposed judgment. Now, wife objects to the draft judgment, claiming that it did not accurately reflect the marital settlement agreement. Father then does what often happens, is he files a CCP 664.6 motion requesting to enforce the settlement and enter it as a judgment. Wife objects, and she says, let's let the mediator resolve any of our disputes prior to the court entering the judgment. And the hearing is then continued. Now we're in June of 2018. Husband wants to get a second bite at the apple and maybe wants to make this all go away and finish this up. And so he files a supplemental declaration and he says, well, you know, here's your second proposed judgment. I've included everything that wife objected to, and now this new proposed judgment is a mirror image of our marital settlement. However, unfortunately, before the court has a chance to rule on the 664 motion, wife unfortunately dies. Now, neither party appear in June, and the court, unaware that any parties are deceased, signs the judgment that was given to him in this motion. This is a little strange, but that's what happens. About a month later, in August, both counsel finally appear, and wife's counsel correctly argues, court, you don't have jurisdiction anymore by operation of law due to wife's death. You need to dismiss the case. Husband doesn't object. Nobody says anything about the judgment. Maybe they didn't get it yet, who knows? So court dismisses the case. At that point, a couple of months later, husband files another motion, now asking to set aside the signed judgment pursuant to CCP 473, and also on the grounds that the final declarations of disclosure were not filed. The trial court grants husband's motion, vacates the judgment, and says, sorry, I signed the judgment by accident. I didn't know that wife had died. So now it starts getting a little more interesting. Adult son files letters of administration in the probate court. Husband opposes, and he files his own petition for probate of wife's pour-over will. The probate court eventually denies son's petition and finds that husband is a surviving spouse under Section 78B of the probate code. The court finds that husband did not waive his right to inherit under Section 141 of the probate code, and rules that the marital settlement agreement was not a complete property agreement under the meaning of Section 145 of the probate code. Goes up on appeal, and the Court of Appeal reverses. The issue was whether husband, in fact, waived his rights as a surviving spouse under the probate code, specifically whether the marital settlement agreement constituted a complete property settlement, and whether the fact that the final declarations of disclosures were not filed indicated that there was not a fair and reasonable disclosure. So husband first argues the marital settlement agreement was not a complete property settlement because it didn't explicitly say it was a complete property settlement. And what the statute under 145 says is there is a waiver, but only if there is a complete property settlement entered into in anticipation of divorce or separation. The court looked at the marital property agreement and it said, well, it doesn't, first of all, there's nothing in the statute that says that the MSA has to say specific language, but if you look at the agreement, it was clear that the intent of the parties was that this was a final resolution of their marital property. And even if wife objected to that first proposed judgment, she wasn't objecting on the fact that there was property that wasn't included. Also, husband's saying it's not a final, it's not a full property settlement, yet he was the one who filed the 664.6 motion. And so obviously he thought it was enough to get a judgment of divorce based on the MSA. So once the court made that finding, the husband then said, well, we never filed our FDDs, and so therefore there was not a full disclosure. And under a different code section, that means that that was not sufficient and disclosure of the parties' finances. And the court said, you know what, even though the FDDs were not done, again, looking at the marital settlement agreement, it does appear to be a complete agreement. And even though there will not be a dissolution, right, because the family court has lost jurisdiction, under the probate code, husband waived his rights as a surviving spouse, and adult son wins. Next slide.
Okay, so this is, I believe, the only California Supreme Court case in our slide deck today, and it deals with what if I could hear everybody on the call, I'm sure I would hear a collective groan when I say it deals with the 2 times the fun issues of civil harassment restraining orders and homeowners associations, because those are 2 things that bring so much joy to attorneys and judges. What happened in this case is respondent Doe was a resident of this condo association, sought a civil harassment restraining order against petitioner Olson, and at the same time filed a civil lawsuit against Olson and the homeowners association. Olson filed a cross complaint for breach of contract, and what had happened was during the civil harassment restraining order process, during mediation, the parties entered into agreement that contained a non-disparagement clause. So Doe filed a special motion to strike Olson's cross complaint under an anti-SLAPP statute. The Superior Court granted the motion. Olson appealed. And really what the Supreme Court was considering was the subject of that special motion to strike the cross complaint and whether the civil lawsuit violated the non-disparagement clause in the parties' mediation agreement that arose from that initial civil harassment restraining order request. And the question was whether or not that non-disparagement clause made in the civil harassment context applied to the statements that were made in a later unlimited civil lawsuit that arose from all the same misconduct. And the court considered all of this and found that the civil harassment restraining order mediation agreement as a whole, when it was considered with the statutory context in which that part was negotiated under 527.6, and the fact that it would implicate constitutionally protected petitioning activity, in other words, the unlimited civil lawsuit, it led the California Supreme Court to conclude that the non-disparagement clause would not apply in the later filed unlimited civil case. So just because that non-disparagement clause was agreed upon as part of the CHRO matter, it didn't carry over to the unlimited civil case. So again, not a huge issue for us on a daily basis in the family law courts, but since it was the only Cal Supreme case, we felt we should include it. Next slide, please.
Okay, this case is definitely the I case of 2022. If you're a practitioner who's sworn off premarital agreements, you can read this case and sleep well tonight. It's a good read. It's a good read to make you feel like you made the right decision. If you are still doing premarital agreements, it's a worthwhile read because it really does delve into what a lot of prenups kind of take for granted, which is whether the prenup will apply both at divorce and death, and all the language and often boilerplate language about inuring to the benefit of your heirs and otherwise, because this is a case where husband and wife signed a prenup and leading up to the signature, wife said, well, I don't want this to apply if we die and we're still married, and tells her attorney accordingly. And her attorney shoots off, because there's only days left before the wedding, shoots off a quick email saying, my client's, something to the effect of, my client's not agreeable with this functioning during, if one of them predeceases the other. And here's a couple of the provisions in the agreement that we take issue with. Not really exhausting all of the provisions in the agreement, because as we know, especially with boilerplate in prenups, there are several places that often refer to what occurs upon death, or what the parties will inherit or not inherit, and what benefits inure to the benefit of the heirs. So she touched on a few of them, set up a time to meet up with her client to follow up. And lo and behold, before that time to meet with her client decided to meet with opposing counsel and her husband, her soon-to-be husband, and signed off on the agreement without reading it. So there's a lot of perplexing behavior. And what ends up happening is, lo and behold, husband dies, and this case is in probate with his family trying to administer the estate pursuant to the agreement, and wife now seeks to set aside or invalidate or rescind. She really throws everything against the wall to see what will stick in terms of contract defenses to make this prenup go away. And what's interesting is it's definitely, and in the footnote, with no surprise, her counsel was sued for malpractice. There were claims as to the miscommunication resulting in a mistake of fact. There's a discussion as to whether both she and the attorney were mistaken as to the effect of those provisions based on the fact that the attorney did not particularly articulate all of the points in the agreement that related to the issue presented by our client. But all of that was really fallen by the wayside because the court really focused on the duty to read the agreement, who bears the burden of a mistake of fact. It's very interesting in the context of contract defenses, the nitty-gritty of contract defenses in the context of premarital agreements. I think one of the interesting citations to bonds almost seems to intimate that in some ways contract defenses may be easier to make in a premarital context. There is discussion also about what, if anything, would this other spouse or soon-to-be spouse, what is their conduct and their misleading or otherwise defrauding the other party into believing the changes were made. There's some discussion about that, but mostly it really is also, what I find is interesting is, at least when I was doing prenups, often you tell your client to talk out certain things that you might be able to get more consensus on than between attorneys. And this really says maybe you shouldn't do that, because the distinction between what the attorney says and what the parties say to each other really became an issue in this case, because the husband's family essentially said, well, he just told her to like talk to my lawyer, and we were there and we heard this. And he always wanted it to apply during death as well as divorce. And wife said, well, we had a conversation about it, and he led me to believe that, yeah, he agreed with me that we should take out the death provisions. So it's a cautionary tale about proper communication. It's a cautionary tale about what do you allow your client to deal with directly, as opposed to retain that authority. It's a cautionary tale about following up with your client about don't go to meetings that I'm not at. And also a cautionary tale about something that probably a lot of prenup attorneys don't do, is take for granted that boilerplate language and explain to their clients that this isn't just about a divorce. This may also be functional if he or she dies before you. So really worthwhile read. I feel like the last year's case on prenups and now this year's case, I feel like the Court of Appeals is really enjoying these prenup cases, because it's this crossover of family law meets contract law, and I think that that's something that they really sink their teeth in, and then they can make side comments about, what would have happened if there was a fiduciary duty in place, and they can have a footnote there saying like, yeah, that family law concept is interesting, but let's deal with the contract. So it's a really worthwhile read if you're still doing prenups. I think it should change a little bit how you proceed on the initial drafting and setting out the parameters, but also how you curtail communications that you're not aware of. So good case. Next slide.
Okay, so this is In Re Marriage of Kim and Zucker. I do note that we are at 7 o'clock already, so I'm going to try to summarize this a little bit quicker than I might. Really interesting case that has to do with the validity and enforcement of prenuptial agreements. So in this case, Zucker was clearly the more sophisticated litigant, made a lot more money, made a significant salary, and received significant bonuses. The wife in this case had a lot of issues, mental issues, and had struggled with mental illness throughout her earlier life. And when they got married, there was a prenuptial agreement drafted prior to marriage, I'm sorry. It went through several drafts. It was drafted by husband's attorney, but both parties had attorneys. Husband's attorney provided the prenuptial agreement to wife's attorney, and wife's attorney read it and advised wife, don't sign this. And in writing said, you should not sign this. You're going to be giving up a lot of rights. But nevertheless, it was signed. Fast forward, the parties divorce, and there is an issue of whether or not the prenuptial agreement was valid. During the trial, the forensic accountant of wife had formed the opinion that wife would need about $86,000 per month to meet the marital lifestyle based on an income available approach, and merely $37,000 per month on an expenditure approach. Wife was unemployed, but had spent the entire marriage raising the couple's 6 children. So, but what the Court of Appeal really looked at was whether or not the provisions of the agreement could be enforced as unconscionable at the time of enforcement, not at the time of creation. So they said that in considering whether a premarital spousal support agreement that was entered into between 86 and 2002 is enforceable, that the court is not limited to a determination of whether the agreement was unconscionable when executed, but the court retains power to shape public policy regarding premarital spousal support agreements, to the extent that it's not inconsistent with any legislative declarations in that policy, and declare that a premarital spousal support agreement is unenforceable as against public policy solely because it is unconscionable at the time of enforcement. So that's really the takeaway from this case, but it's a really interesting case. So next slide, please.
Okay. AF and Jeffrey E is interesting, but more so in the context of forming attorney-client relationships and conflicts of interest. What happened, and this is unfortunately not an uncommon fact pattern. A child seeks appointment of a guardian ad litem through the other parent, essentially, and in this case, mother sought a guardian ad litem appointment and ultimately requested that her previous attorney serve as the child's guardian ad litem. And the court engages in really focuses in on the basis of the disqualification that the trial court decided, and really delves into different analysis of what conflicts mean between simultaneous versus successive representation of parties, and essentially really focuses in on the basis for the disqualification and its reversal. But I wonder if this is one of those cases where procedurally it's all very interesting. It might be an intellectual exercise, but ultimately it appears to be a distraction to the underlying case, because it would appear that once it's remanded and the court then looks at the correct successive representation and also thinks about what the guardian ad litem's position is in the context, it doesn't appear that this attorney will survive a disqualification motion eventually. But that's what, at least my take on it. If they're serving the guardian ad litem's as the guardian ad litem's attorney with the previous representation of mother, eventually the court will say, what are we doing here? If this is causing all of this extra hassle, why not just appoint someone else for this child? So it kind of bounces it back and says, it wasn't a proper disqualification, but maybe in the future, there might be a basis. So that's this next slide.
Okay, so this is a case that is bound to get a lot of attention because it deals with the hot button issue, an issue that's been hot button for as long as I've been in practice. which is what is minors counsel's role? And you have people lining up very vociferously on both sides of this argument. And many years ago now, Family Code Section 3150 about minors counsel sort of evolved and changed. There was a lot of complaints that minors counsel was busy making recommendations as if they were an evaluator in some form. There was a lot of noise about the fact that judges were simply rubber stamping minors counsel's recommendations. So Family Code Section 3150 was amended. And in some respects, the redefinition has caused a lot of confusion over the years. And one of the major points of confusion is whether minors counsel can make recommendations, which some people feel makes them sound like an evaluative person rather than just another attorney. And Family Code Section 3150 tried to outline their role as another attorney on the case. And as such, it was inappropriate for them to make recommendations because after all, they were just another attorney on the case. They weren't doing an evaluation. They weren't recommending to the judge based on evaluative data what the custody and visitation order should be. So no recommendations for minors counsel. And indeed in my court, since then, there haven't been any recommendations by minors counsel. The problem was in treating them like every other attorney. They were then allowed to argue their case and make final arguments. And it didn't take a rocket scientist to understand that their final argument was basically their recommendations. And so this sort of semantic legal fiction has proceeded for a number of years. And happily, or depending on what side of the case you are, unhappily, this case really eliminates this particular element of the semantic game playing when a court particularly chooses to request recommendations from minors counsel. Now, I gotta tell you, part of this issue is really rooted in the determination as to when the court needs or should be appointing minors counsel and or when they need clinical custodial data and evaluation. So I can tell you how, my threshold as to how I start off with this decision as to what I need. And if there are factual discrepancies that are relevant to the best interest of the child, or a situation where neither side has presented relevant or admissible evidence to me, as opposed to what they often do, which is just vilify each other, I'll appoint minors counsel to go out as any attorney would, gather admissible evidence, and present it to me so I have evidence in order to make an order in the best interest of the child. I can say to them, look, nobody's bothered to give me the kid's report card and introduce it to evidence, to speak to the, find out what's happening at school, bring me the IEP, whatever it may be. I have no evidence, admissible or even otherwise. And I'll appoint minors counsel to go out and act like every other attorney and gather admissible evidence and present it to me. Now, when there are clinical issues that are very apparent, such as bipolar disorder, schizophrenia, refusal to visit, alienation, some of the Lamouche factors. Well, in that case, I look to a 730 expert, a clinician, for a PPA, or if there funds a full evaluation. But I decide there are clinical issues upon which I need expert testimony. And so those are not cases necessarily where I look to minors counsel. Now, there are also many of my colleagues will use hybrid versions of this, where there are already clinical experts working the case. Many of them, often many clinical experts who's had a taste of it, And Meiner's counsel is used as sort of a conduit between the clinical experts and the court, which is often a huge amount of time and money savings for the litigants. In other words, it's expeditious to do this. And if I ever do something like that, I get everybody's agreement as to what's to be done. Now, in this case, mom had married someone in the military and wanted to relocate with the minor so she could be with her husband. She had made 2 requests. Both times the court denied the move away. Then mother heard from father's girlfriend, who told her that father had assaulted her and he'd driven while intoxicated with the minor child in the car. DCFS was investigating, and the court appointed Meiner's counsel to represent the child and see what DCFS, or Santa Barbara's version of DCFS, was finding. Now, both parties agreed that Meiner's counsel would come back to the court with a recommendation. Now, initially, father's custody was restricted to alternate weekends on a temporary basis. And after mom hears the evidence from the girlfriend, she files a 3rd move away request. There were hearsay objections to things that were in the court file, like the DCFS report, which Meiner's counsel had lodged. And they were overruled by the trial court, who relied firstly on the stipulation of the parties to receive recommendations after DCFS had done their investigation. After trial, father admitted that he'd been drinking while driving the children, but he denied he was intoxicated, even though he ran his car into the curb and had to be towed away. He also admitted to violence in front of the child. And the court found a change in circumstances and granted the move away as in the best interest of the child. As for the recommendations, the Court of Appeals points out that there was a stipulation that Meiner's counsel would bring back recommendations after reviewing the DCFS findings, but the appeals court goes on to make clear that even if there was not a stipulation, the semantical distinction between Meiner's counsel presenting a legal argument and making recommendations is a distinction with no substantive difference. Call it what you will, Meiner's counsel can basically say what they think. Now, again, I think a thoughtful judicial officer will still use the kinds of guidelines that I talked about. I certainly don't want to hear Meiner's counsel making clinical observations or presenting me with clinical data and giving me kind of evaluative stances on clinical issues. And I'm not going to hear that from Meiner's counsel. I don't care whether it's a recommendation or whatever they want to call it. But Meiner's counsel definitely has the ability to make their argument, call it a recommendation, call it an argument, call it whatever you want. As for the hearsay argument that there was stuff in the file, DCFS report and stuff, no general rules really comes out of this case. However, let me share with you that whenever I appoint Meiner's counsel, whenever I get a hearsay waiver from everybody at the table. Now, this is different than a Sanchez waiver. Remember, Meiner's counsel is not an expert. The waiver allows me to have Meiner's counsel's report on what they found and who they've spoken to and who told them what, including the child. Now, if there's a refusal to grant the waiver, which there rarely, if ever, is, I order the cost of the subpoena to the third parties. I order the cost of the subpoenas to the third parties and their appearance fees paid by the objecting party. If they're objecting, okay. Then we won't have Meiner's counsel tell us anything. You can subpoena those people. Now, finally, there's an argument regarding procedural requirements around move away requests. Father claimed that there was no finding of changed circumstances prior to the court allowing the move away. Realistically, in move away cases, there's always a changed circumstance. The parent wants to join her husband. There's financial hardship living in California. Someone got a job transfer. Now, if there are no changes in circumstances, it's usually because there's an impermissible purpose behind the move away, and we're restricted from ordering move aways if there's an impermissible purpose. So I don't think it's usually an issue. I think the real hot button thing about this case is, are they reopening the door to minors counsel being these sort of recommending parties, these sort of evaluative parties? Or are we sticking to what the code section rewrite tried to fashion of their job as just another attorney on the case who's bound and subject to the same rules? And I think the Court of Appeals is saying, well, yeah, they are that, but they have a special role. And that kind of goes along with the fact that as attorneys, they're not only charged with presenting their client's case, they're also simultaneously charged with acting in the best interest of their client. And it's not always the same. Those two things are difficult to balance. And I think there's going to be a lot of controversy around the case. I think that we can avoid a lot of controversy if judges are careful as to how and when they appoint minors counsel. And if we're thoughtful about that, and if we remember they are still attorneys in the case, but there's this special overlay. Now, my colleagues, I know we're short on time, but spend a minute, because this is a case that impacts all of us. And what do you all think about that?
All right, next slide.
All right, nobody wants to opine. Next.
All right, this is a relatively simple factual case, but it's a cautionary tale, not just for family law judges, but also for lawyers. You know, it's often been said that lawyers should ask for sanctions more, judges should issue sanctions more, but if you're going to issue sanctions or you're going to ask for sanctions, make sure you're asking for it under the correct code section and that the underlying facts warrant it. And this was a case where it was not. So, you know, you never really know what happens in the backstory of these cases. But this is a case where a family law judge clearly was frustrated with the mother in this case. So first she files her initial declaration without a lawyer, asking for very limited visitation. This was a parentage case which was filed 2 months after the child was born. And basically, I mean, we see this all the time. The mother says, well, the father travels a lot, he's not around. He should only see the child a couple of hours a week, and he should give me 2 weeks notice each time he wants to see the child. So at the first hearing, and it's interesting, this case, the Court of Appeal was clearly looked very carefully at this case and did a lot of quoting of the judicial officer. And, you know, quoted the court right from the get-go, saying that the court was very concerned about the manner in which the mother had drafted her motion, and noted that she seemed to be wanting to be in complete control, and cautioned her that in the court's, you know, view that both parents have equal rights to this child. And made some preliminary orders and also said, I'm going to side completely with respondent, that was father today. And I think in the future, you're going to have a really hard time because I've tried to explain it. You don't feel like he's an equal parent and you feel like you need to drag this out and make it slow. At that point, mother gets an attorney. She files a untimely disqualification request under 170.1. That's denied. The judge makes some comments about that motion, says I probably shouldn't really say much, but you know, you shouldn't have waited. And you know, I think in Judges College, we get the admonition, never say anything. But again, you know, we all have cases that get under our skin. So then mom files a proposed judgment, and now the court rejects that. And again, expresses concern that it was an incomplete judgment, and again brings up her initial declaration. So the judge keeps going back to that and feeling like the mother is just not moving forward enough. Father requests sanctions under 271.1. Eventually, the court issues sanctions sua sponte. And while they're talking about the sanctions, and the court says, well, you were noticed about these sanctions because the court at some point put off filing, they start talking about video calls. And mom says, well, I really only want video calls to be done through the Zoom because I can record them. To which the court again expressed mother's tone of control, and that she again wanted to be in charge. And the court said that it found that offensive. So basically at the sanctions, the court said, okay, there's 4 reasons why we want sanctions. 1, mother's original declaration. 2, the motion to disqualify. 3, the judgment because it was replete with errors and omissions. And then 4, you want to now record the Zoom calls between father and child. So the court issued $10,000 sanctions against mother and her attorney, each for $10,000. Now, of course, the immediate problem is that under 271, you don't issue sanctions against an attorney. It's against a party who frustrates the policy to promote settlement and cooperation in a family law litigation. The second, third, and fourth problem was that while mother's actions may or may not have necessarily promoted good communication with the father, they could not be shown to have frustrated the policy to promote settlement. And so the court overturned and was none too happy with the trial court, especially the fact that the trial court said things like that mother's requests were entitled, controlling, and overreaching. Not a very complicated case, but certainly a word of caution. Next slide.
All right, so this is In Re Marriage of Knox. And, like Judge Pellman was saying, not a particularly complicated case, but I think a really important case, maybe more so for the judicial officers on the call than the attorneys, but certainly something the attorneys should always keep in mind and maybe include in their points and authorities if submitting same. So this was a dissolution proceeding where the wife had requested need-based pendente lite attorney's fees under Family Code Section 2030. And the court, as happens sometimes, deferred ruling on that request, and it went all the way past trial, and the court was going to make a ruling on attorney's fees as part of the judgment on reserved issues. The opinion has a nice discussion about Section 2030 and really focuses on the statutory language of 2030 and A1, for example, which says that in a dissolution proceeding and in any proceeding subsequent to entry of a related judgment, the court shall ensure that each party has equal access to legal representation, including access early in the proceedings. And the court made findings, the Court of Appeal made findings that those phrases unambiguously require the family law trial judicial officers to hear and resolve pendente lite requests for attorney's fees during the course of the proceeding and not as part of the final judgment or the judgment on reserved issues. So in other words, a family court that doesn't make those rulings early on or until after trial, the Court of Appeal found that the court is failing to ensure that a self-represented party has access to legal representation during the proceedings if they don't make those requests early on. The more specific requests of timing were sort of how quickly a family court has to hear a request for pendente lite fees after it is submitted to the court, and how quickly the family law judicial officer has to decide that request after it's heard. The latter question is answered by statute. It's 2031A2 that the family law judge or commissioner has to rule on the request within 15 days of the hearing. So there's that deadline that's set, but the family code doesn't expressly impose a deadline for hearing a request on the pendente lite attorney's fees, or I suppose limit the number of continuances. But I think in re Marriage of Knox is pretty clear from its tone that these cases, these requests rather, need to be heard early on in the proceedings to ensure that both parties have access to legal counsel. So my practice at this point has been, even if I'm going to be continuing other parts of an RFO that includes an attorney's fees request, I'll always make sure to address the attorney's fees request, even if I'm going to be continuing some other part of that. Next slide, please.
Okay, our last case, and we have about 2 minutes. This is another case in the line of sanctions orders relating to unwarranted disclosures of child custody evaluations. We've had Anka, we've had Harriet, and now we have Shenafield. And it relates to an attorney and both a sanction against an attorney and a party when they filed a declaration in support of an RFO, which disclosed wife's prior child custody evaluation in a case with her previous spouse. So clearly not very similar to the fact pattern in Anka in terms of what was disclosed. The manner of disclosure is a little different. Now it's in a declaration. There's also a one sentence reference to father having possibly also published a portion of it on Facebook. It's interesting. There's not much delving into what that means, because what was really at issue is, interestingly, counsel just appeals the sanctions award against her. So, and really throws the gamut of the main arguments made in Anka that I'm not a party that will be subject to a sanctions award. It wasn't properly noticed to me, all of the standard things that we've seen in previous orders. And there's definitely a level of aggravation by the appellate court with counsel. It goes to painstaking lengths of quoting statements made by the attorney during a mediation with the parties that was recorded by wife, because she had a restraining order against husband at the time and lawfully recorded that that discussion, which included attorney berating wife and bullying wife. So even though I didn't see a lot of reason as to what that had to do with the disclosure, the appellate court definitely wanted to quote some of the things the attorney said in that meeting, which I think highlights the aggravation of the embroilment of this particular attorney. Ultimately, much like Anka, it doesn't really set out any new concepts. It pretty much reiterates the same things that we saw in Anka and Harriet, which is an attorney is subject to sanction. I think the part that's interesting in this is what is proper notice for a sanction under 3111, subsection D and 3025.5, that in this particular case, doing it in the responsive pleading was sufficient because subsequently it was set for trial and hearing, and that was deemed to be adequate due process, and everyone was placed on notice that the issue of sanctions would come up at the hearing. And I think it's important to not overextend the rule that Shennefield kind of discusses in terms of what's appropriate affirmative relief that can be requested on a response, because we hear this a lot in court, that this is an overlapping issue. Why don't need a separate motion? It's right on point. I can always ask for attorney's fees. Well, I think Shennefield says there needs to be some overlap. And at any time, the court has the discretion to say, I'd rather have that as a notice motion and allow for due process to go forward. I think there has to be a distinction between understanding when courts have allowed it to be in a responsive pleading and proceeded that way versus the court is required to take it under a responsive pleading. We hear a lot of argument by counsel that the court is required to take it once it's pled in the responsive pleading. I don't think any of these cases in Shennefield really stand for that proposition. It just says it can be, and it could be proper due process. And if it's set out properly and given notice in terms of, as Judge Pellman previously said, you highlight what the sanction is under, what code section, it could be. But that line that every attorney I've heard saying, well, you have to, I don't have to file a separate motion. I don't think we've seen that authority yet. So Shennefield, not much new on the unwarranted disclosure and still holding the line on affirmative relief on a responsive pleading. So I appreciated this case.
All right. Well, thank you all. I'm sad to say we don't have time for any questions, but wonderful panel, and thank you, audience. Good night.